reset for the state to get in touch with the son, and I believe that they have.
Yes, we have heard from the son. He said that he is okay with amending the bond conditions. He is okay with allowing her to come to his games and is okay with her, with communicating with her over the phone. But he said he's already doing both of those things. But he made it
But
clear
she's
that
not supposed to have contact with her. I mean, what the hell? Why do we have court orders if no one's going to follow it? Really? I mean, we're supposed to know about these things and we take action on it. You can't just do whatever the hell you want to do, which is what's going on.
Judge, it's an allegation that has not been presented for me to
But a
defend.
court order is a court order.
An
you know,
allegation of a violation of a court order that needs to be, I need to be noticed so I can defend it. I can't
I
defend it
get
on
it.
the
Well, that's
fly
what I'm
today.
saying, you know? If there's a violation, you got to let us know so we can take appropriate action,
yeah, Judge.
you know?
That she is in the process of doing the PTI work to get the case dismissed. And
It doesn't make me feel better that she's still violating court orders, you know?
I know, but I tell you that to argue the point that this case is probably going to be disposed pretty quickly anyway.
I understand.
So we would just,
So you need to let me know when these issues come up so we can take appropriate action, you know? I mean, how are we really supposed to let her go to the basketball games and this, and she's not gonna have contact with him? I find that hard to believe that's gonna happen because she's still having contact with him now.
Judge, last time you said that you would not be amenable to that.
Contact with him now.
I can't control that, and I don't have any allegations in front of me to respond to that. I hear the court loud and clear on that. But I did relay last time that the court was not amenable to the contact at the games because she was here and that she heard everything. And so we were just coming back to see if she could at least amend it for the phone and have it. So if she is in violation, which I'm not admitting she is, she would no longer be in violation on that, in that regard. And then hopefully she'll get this PTI done by the end of the week, and this is the last you'll hear of me on this.
Setting this case for Monday. She must be here Monday if she's not done with it. And then I'm gonna take,
Hold on just a second, please. What day am I in? Monday is, I don't even know what day I'm in right now, Judge, sorry. It's been a long
day
week.
next week, Ms. Teachy.
Be
Anything but Friday.
the easiest for me to make sure that I can be here, Judge, is that, because I have
That's okay.
appointments in the 8, in
Okay.
court 8, and I can just pop over here with her.
I'm okay with that.
3/8, and she's got to be here and she has to be finished with the PTI?
Or I'm setting a case for trial. And then we'll respond to the, you know, allegations. But I'm not happy with her, you know, I'm not gonna acquiesce. She's doing whatever she wants to do. You need to reach out to her now that if she continues, then I'm gonna take appropriate action. I'm not gonna agree to this now. I mean, she has a week left. Let her do what she needs to do, but she's continuing to do what she wants to do anyways. And please reach out and let her know that or let him know that no means no.
Yes, Judge.
Okay.
All right, Judge, I will
Thanks.
tell her that the court was put on notice of the violations and is now either get it dismissed or
We'll
we're
have it
gonna go to trial. I was just appointed, but
Okay.
I'm being punished for her, but we can address that on.
Set it for trial if she's not done by Wednesday then.
Okay, thank you so much.
All right. Ms. Strong.
Hello, Elio Jose Guerrero.
Hold on a second. Real quick. I have it to Ben. You ready?
Yes, sir.
Good morning, Mr. Glover. Got it. Okay, so Mr. Glover, you have picked up a burglary of a motor vehicle. You've also picked up an assault of a family member. On both of those cases, you're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement where they're offering you 120 days in jail with credit for the 66 on the assault and 68 days on the burglary of a motor vehicle. They will be there for the rest of your life. On the assault case, there's an affirmative finding of family violence, meaning if you pick up another one of these, you will be facing a 3rd-degree felony 2 to 10 of the penitentiary. And if you've been to the pen, it could be just, they can continue to enhance your punishment, perhaps 5 to life, 15 to life. Do you understand?
Yes, sir.
On the burglary of a motor vehicle, that is also an enhanceable offense, meaning you continue to pick up those cases. At some point, they'll hit you with a felony on that as well. Do you understand?
Sir.
From now on, you're facing a minimum of 90 days in any misdemeanor court here in the state of Texas. Any misdemeanor you pick up, it's a minimum of 90 days in jail. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. Disagreement, there's no turning around. This is stuck. It'll be there forever. Is this what you want to do?
Sir.
You also need to understand that if you're on parole, pleading guilty to both of these cases, they may revoke your parole, sending you back to prison. What is ISF? I don't know what's going to happen, but they can revoke your parole, send you back to prison. Do you understand?
Yes, sir.
You still want to do all this? How do you plead to the assault and the burglary of a motor vehicle, guilty or not guilty? I'm going to find you guilty. I will sentence you to both cases. I'm going to roll your court costs so you won't owe anything. Good luck to you, Mr. Glover. Thanks, Will.
Thanks, Judge.
All right, Ms. Strong, I'm sorry.
Yeah, so we have Jose Guerrero. This is an old case. It's from 2020.
You have another Guerrero?
Yes,
Okay.
it's an old case. It's from 2023. The state wanted a 30-day reset to look over the case
It
to
was a
see.
2B warrant, Judge.
Okay.
We
Is
tried to-
discovery complete on the case?
It says the 911 call is still in progress. It was requested on the 14th, but I mean, if it's from 2023, I don't know if they would still have records for 911.
Yeah, I think they keep them,
Oh, wait, no, that's on the felony. I apologize. Yes, discovery is completed. Besides, we need to subpoena for the medical records.
do you have an offer in the case?
No offer yet because this case just came onto my docket, so I'm trying to reach out to the complainant to see if I can get.
Okay. So he's really just, it's been in,
Yes. The first setting on this case was on January 13th, 2025.
yes, so they filed it to be December of 23. And looks like he didn't get picked up until, January of this year. So we'll just give you like a normal,
Thank you.
just, right. So it's like, how long have you been on it? Did you just get appointed?
Yes, well, I've been on since the January.
Do like
setting.
settings. I mean, you don't have to just have 30 days. Well, normal because it's been in just 2 weeks.
Okay.
Right?
Thank you, Judge.
Okay.
Can I approach?
Yeah.
Judge, I'm approaching on an off docket. If I can just give you the cause number 1 second. Let's see, Judge. So Judge, you ready for the cause number?
Okay.
It's a 252-6711. It's a net of this. He has a bond violation report that I think is, if it hasn't been filed yet, it'll be filed soon.
I see it.
Okay, Judge, he missed a drug test.
Do you hear now?
Judge, he went to Arizona. His mother's in the hospital. She's diabetic and she has a lot of health problems and she broke her ankle. And so he went to Arizona kind of as a family emergency to take care
Well,
of her.
let's do this. I'm going to give him a week to go to a Quest diagnostic
Okay.
and get it to us.
Yes,
If he
Judge.
doesn't, then I'm going to revoke his bond.
Yes, Judge, for that, I will have to make an amended order for him. I can't do anything right now. He's actually been on my computer for like the last 30 minutes because everything is broken.
Ah.
But as soon as I can, able to
Okay.
get into it.
So he has a week to go to Quest and get the result to us. If he
Yes,
doesn't get
Judge.
it done, then
He said that he could be back by about April 9th. He's just been taking care of his,
I get, but
but
he's
you want
called.
within the next week.
It's supposed to, right. So
Have him
he's,
go to Quest
let
Diagnostics.
everybody know. So you know what I
I
mean?
can get that information from pretrial services.
Okay.
Just tell him to
Hey,
call.
but it has to be Quest,
Quest Diagnostics.
like
Okay.
not Punka City drug testing.
Right.
Right.
Okay.
Okay.
He just has to call.
Thank you, Judge.
Abel's on.
I always tell him to call pretrial
Oh, you got it? Okay.
So-
I have to give this to the state so they can see it too. I just wanted to, so if you want to make a copy
Yeah, let me look at it.
and then,
Also, for last week,
is that your case? Abel, what's the cause number?
It's 255-4344.
Only thing anybody.
It's two cases, Judge. And it's, yeah, it's two cases.
Sebastian, is that, did you get it?
255.
Or 344? There's two cases.
I don't know if it's back, so I'll come on.
Thank you.
Miss Williams, Raquel. I think she may be the last person.
Okay,
The last time we were here, you asked me to submit information for a PTI. We were supposed to get that together. I have not done that. It's on me, not her. She submitted it to me.
we've been working on it since January. We're now in March.
She did, she sent me the information. It just was pieced together and I've been out. I haven't been well, so I just need some time to
So we can give you a week.
together. That's fine,
Is
Judge.
that enough to get it in?
You will give me a
Okay. Yes, ma'am. Okay, yes, ma'am.
Alrighty.
Hey, bottom on page 29, 1 week, please. Is that enough, Miss Moore?
I'm actually going to ask for it to be Monday or another day that I'm here, so I can get.
To do
To
what?
submit the mitigation packet.
Oh, we're time for the.
Mr. D.
Yes, sir, Your Honor. Judge, we're approaching on Mr. Joshua Connor. The last time we were here, I'd informed the court and the chief that I was having problems downloading the last time we were here, we didn't have the videos. And you had given us to the day to get that video. The chief has provided me a video, but it will not download. The chief is thinking about just getting me a USB to look at. But he has the video. I've looked at it on his site, so I know it's there.
Okay.
That's been shared before, I think it should, for the issue.
When do you think you can get it to him?
If I can run downstairs and get a USB, I can do it today.
Okay, let's see. Can you just get a bit of time and he can get it to you today and then we'll give you like a week?
Yes, sir. Yes,
We're
sir.
short staffed today, so just.
Take your time. I'm here.
Go to it.
Okay, take your time. I'm ready.
The bond conditions aside from the ones from the magistrate.
Is this the one that we revoked?
No, that was Guadalupe Guerrero. What Jose Guerrero, we were just talking about if that was the to be.
He's in jail?
No, he's here.
Come up, Jose Guerrero. So he has a felony assault from January
Yes.
and then our assault here. Let's do PC because I don't remember anything.
Okay.
Morning, Your Honor.
Mr. Guerrero, you are charged with assault causing bodily injury. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On June 14th, 2023, an officer was dispatched to a residence in reference to an assault call for service. The complainant entered into a storefront to make the report. The officer identifies the complainant by his Honduras identification card. The complainant stated that he and his family were at their residence in Houston, Harris County, Texas on June 10th, 2023. And he stated that some friends later identified as the defendant came over to the residence to discuss the complainant working at their residence located in Cleveland, Texas. The complainant described the defendant to be in his mid-20s to early 30s, and they were all sitting around. And Ms. Fugon asked the complainant if they could drink while they ate. The complainant did not have any issues saying yes to the request. They could play music while they ate, drink beer, and talked. The complainant stated that while he was looking down at his phone attempting to start playing music, the complainant's son, Jose, struck him in the face with his left side, causing it to be swollen. The complainant stated he believed it was a close fist punch, but was not sure due to him looking at the ground at his phone. After the defendant struck the complainant, all three parties left the premises. The complainant stated that after the altercation on June 11, 2023, he felt pain and discomfort in his mouth and thought it was a broken tooth, but the pain got increasingly worse, where he felt like he needed to go to the emergency room. The complainant went to the hospital at a later date and then called officers on 213.
Okay, so what happened in the felony case then, please?
Yes, so on January 12, 2025, an officer met with the complainant who stated her boyfriend grabbed the complainant by her arms and squeezed them, causing pain. The defendant then punched her in the face and threw her to the floor. The defendant then stomped on the complainant's head several times, causing pain and for her to bleed from both ears.
Mr. Guerrero, I'm going to find that there's sufficient probable cause to go forward with your case. I'm going to do everything in my power to protect every person of Harris County. Do you understand? If I find that you become a danger in any way whatsoever, I'm going to make your bond so high you're going to have teeth falling out. Do you understand?
Understand.
You are not to consume alcohol, illegal drugs, unprescribed controlled medication, and I'm going to test you like crazy. In fact, I'm going to send you for a drug test right now. Do you understand? If I find that you're using, it's really not going to go well for you. You're not to have any contact with the complaining witness in this case, not to go where they live. Can you run his license, see if he has a valid Texas driver license? So, Ms.
It says that, oh, wait. It says, the CDL is
Cortez?
licensed.
If you do not have a Texas driver license and or liability insurance in your name, you are also not allowed to drive for a drug test. Now, if you fail to go test, if you fail to come back, a warrant for your arrest will issue. Take the test, you must come back. Okay, take a seat for me.
Council for reset.
All right. Judge, fortunately on Mr. Weber, let me hand these back to you.
State, did you see this? Okay, I'm in, can I,
Yeah.
okay, so, can I file that?
Council
I
for
have seen
reset.
NC's filed and deeds before, so I would imagine. Yeah. Confidential. There's a.
Can you mark it confidential?
Yeah.
I'll put it in seal, I'll put it in seal.
Okay, that's it, seal it. Okay, because I don't, yeah,
That probably should be.
good idea. Okay,
Judge, approach you for PC on this one.
well, hold on a second, I don't even have them.
Needlessly, without probable cause being heard. I was told that that was the reason I was appointed to him this
No,
morning.
no, no.
that
So
he
I
could-
appointed you because we had gotten those two letters. I didn't want to just file it and I wanted to take the appropriate action when we got, because we got those two letters. I don't know who sent it. All I know is that we got it and I wanted someone, that's why I appointed you to see it. I don't know anything about probable cause. I just know that we don't have him here today because I
Right.
guess he's still in processing.
Correct. So you will not entertain hearing probable cause without him.
I guess let's do it. Did the magistrate already hear probable cause? I mean, it looks like a magistrate already found probable cause. You don't think there's PC?
No, Judge.
Okay.
All right, First County, Texas, officer were dispatched from assault call. Officer met with the complaining witness, who stated that the defendant is her boyfriend of 3 years. Complaining witness stated that they got into an argument over where to eat. The complainant and defendant both denied that an assault occurred. Officer then spoke with the witness, who stated that she observed the complainant in her vehicle. And the defendant opened the front passenger door and punched the complainant 5 times with a closed fist. The witness stated that she then observed the complainant and the defendant get out of the vehicle, and the defendant punching the complainant several times with a closed fist.
Wait. Okay, so initially, the defendant allegedly punches 5 times, you said? Or the witness? Or
The witness observed the defendant punch
okay,
5 times. The witness stated that she then observed the complainant and the defendant get out of the vehicle, and the defendant punched the complainant several times with a closed fist.
Judge,
There's no PC?
the CW says that no assault or terroristic threat happened.
Okay, there were
To
two
the
officers.
officers. It's based on her feeling pain, and she's saying nothing happened, Judge. If she's saying that she wasn't threatened, she wasn't threatened.
Well, no,
Whether 20 people or 100 people see it.
well, bodily injury can be inferred. You don't need somebody to say pain. You can infer bodily injury from conduct.
So what about the terroristic threat?
So the complainant at the end, the witness stated that the defendant stated to the complainant, quote, "I'm gonna fuck you up."
Again, if she doesn't take it as a threat, it's not a threat, Judge. We might think it is. And we can infer all we want, but that's not.
I'll refer that one to the court.
Say, okay, so it was it at the time that the alleged assault is occurring? He says, I'm gonna fuck you up. I mean, I think there's enough for probable cause, you know, it's such a low standard, you know?
Well, I don't agree. Let's agree to disagree.
Oh, sure, and we can, right? But we have someone who's punched her 8 times in the head. You're telling me that's not gonna,
Well, I mean, sometimes that behavior is not that it's defensible, but it is permitted under the law, whether it's self-defense. I don't know, Judge. I don't know the whole facts of the case. I just have what the initial summary of the report is.
I think that there's enough PC to
Yes, sir.
start to go forward.
I'd ask that you grant him, based on what the CW wants that the case be dismissed and what she's saying from the get-go, that you grant him PR bonds on these 2 cases.
I'm gonna be opposed, Judge. I don't think that the conduct here warrants any sort of PR bond. I think it was adamant that nothing occurred, and the 3 independent witnesses are saying that she got assaulted, pretty consistent with each other.
So let me read this to you. So let me read this to you because there's more. It says motions for bond conditions, MOAP. Defendant assaulted and made a terroristic threat against the complaining witness, yada, yada, yada. Complaining witness denied same. However, there are numerous witnesses who heard the threats and saw the assault. Witness Kirby saw defendant swing at complaining witness 3 to 4 times and assault complaining witness. Witness Grantham saw defendant open passenger door to the car, punch complaining witness 5 times with a fist. Then complaining witness got out of the vehicle and defendant punched her 4 times in the stomach and in the shoulder. Complaining witness Sitpak saw defendant punch complaining witness 5 to 6 times with fists in the vehicle, 3 to 4 times. I think there's enough problems. And I'm not ready yet. I mean, he's in processing now. We'll get him. Because the problem is if I grant a PR bond now, he's going to be out and I can't put conditions on. And I'd like to put conditions on and, you know, we can talk about it when we get him about a PR bond and stuff. Okay. The magistrate set bond on both of the cases. I'll keep it for now and then we can talk about it tomorrow.
Yes, Judge. I also have Mr. Cortez.
Okay.
Would request a PR bond. Don't shoot the messenger on this one.
I will never, I'm never going to begrudge you for, you know, zealously advocating, you know, really. Cortez out real quick, please. Are you ready? Let me talk while they're bringing on.
Yes, sir.
Let me talk. Okay.
I've got an off docket matter.
Okay. What you call it?
It is 2553123.
Okay.
Mr. Haygood,
Yes.
and he's here, and we're asking for a walkthrough. And they've spoken with the complainant.
Let's, hey, good, come up, please. Mr. Burns, are you here on this too? Oh, you have. You are Mr. Haygood.
Sir.
Mr. Haygood, you are charged with violation of a bond condition or protective order. You are facing up to a year in jail and or a $4,000 fine will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay, Sebastian.
All right, on February 24th, 2025, officer was dispatched in reference to a possible violation of protective order and made contact with Patty first. Stated that her ex attempted to contact her via Fortnite on an Xbox game system.
That's my jam. Fortnite? Oh, yeah. That's my jam.
He stated that she received messages under a username, OBT Haygood and LLUVVMEE. Message she received stated saying, "Hey, you, I miss your voice," and then received several friend requests. And she knew that the complainant would have stated that from prior experience, that was linked to the defendants right through the messaging system at the Xbox.
Right. Okay. All right. Mr. Haygood, I'm going to find that there's sufficient probable cause to go forward with the case. I want you to know now that the Texas Constitution does not allow me, but in very, very limited circumstances, to have a hearing to hold someone at no bond. You are now charged with a violation of protective order, and I'm putting conditions on your bond now. If I find that you violate these conditions, I can have a hearing to hold you at zero bond, no bond, and I will do it in a heartbeat to protect every person in this county. Do you understand?
Yes, sir, I understand.
So the problem is that he's got an impeding breath, I guess, against the same person now, right?
Yes, Judge. Just for the court's awareness, with the complainant, she's not on the word or anything. There's some issues with the cases that we'll look over,
Okay.
but just wanted to bring that to your attention.
What about bond? Because we need to set a bond and,
There's a $5,000, or there's, I think they've requested a $5,000 bond.
okay.
I'm asking for a $1,000 bond. And if I may, Your Honor, during the altercation, I showed the state a video that shows her being very violent. And during that altercation, his Xbox was broken. So he's denying I don't know how Xbox works, and I don't know how Fortnite works.
Hey, you never played Xbox?
Judge, my
Is it a
10-year-old plays
PlayStation
it.
or an Xbox?
My 10-year-old plays it excessively, but
You've never played Xbox? You know, come
I
on.
don't. I mean, I've tried a little bit, but 2 minutes.
Oh my Lord. I mean,
I can't.
I know what you're getting for Christmas. It's not the worst in the world, Mr. Haygood, but no means no. And I want you to understand that we're absolutely serious. If I find that you try to message this person through any means, I'm going to put you in jail. Do you understand?
I understand.
I believe that everybody deserves a chance, but I'm only going to give you one. I will not give you any more. Understand? So I'll set the bond at $3,000. I'm going to grant you a PR bond today, but you're not going to get another one. You will sign orders now not to have any contact with this person, not to use any marijuana, not to use any alcohol, illegal drugs. If I find that you're using, you pick up another case or you try to have contact by any means necessary, I don't care what it is, I will put you in jail.
Sure.
You understand?
I understand clear as day.
So it's a bond set at 3. PR bond